All right. Let me go ahead and share my screen. I'm a big fan of slides, so if you ever ask me to present, there will always be a jazzy slideshow to go with it. My name's Hayley Cousin. I am the Executive Director of Community Justice Advocates of Utah. We are a newer-ish nonprofit organization, and we train and support non-lawyers in providing legal services in different areas of the law. And we're going to talk a little bit about how we came to be and our programs, particularly the one related to protective orders, and how you might be able to get involved here in the coming months. Um, so we refer to this work as community-based justice work, and I want to kind of level set and give us a shared language for what that means and why it exists. Um, as I'm sure all of you know or will come to know soon in your work, we have a problem with legal services and people being able to access legal services. On the left-hand side of my screen, your screen, you can see some facts and figures related to kind of the national landscape. So the Legal Services Corporation, which is our big legal aid funder, they fund organizations like Utah Legal Services across the country. They found that low-income Americans did not receive any or enough legal help for 92% of their civil legal problems. So this is things like custody cases, divorce, debt collection, things that our clients are bumping up against all the time. A similar study found that 66% of the US population experienced at least one legal problem in the last 4 years. So we know people have these legal problems, and we also know there are not enough resources available to help people address them. On the right-hand side, we have Utah-specific information. A report from a few years back now found that 98% of debtors in debt collection cases were representing themselves. Virtually all creditors had attorney counsel. In eviction cases, 95% of tenants representing themselves, trying to figure this out, compared to 90% of landlords had representation. And then in the protective order context, 53% of survivors were representing themselves. So we know the need is there. What were we going to do about it? So in 2020, Utah Supreme Court created what was called the Utah Legal Regulatory Sandbox, which was essentially just a space for new providers to come in and say, we have this really interesting, new, different way we would like to deliver legal services, but currently the rules of legal practice say we can't do it. So entities would apply, and then if they were accepted, they'd be able to use whatever their new proposed model was while being subject to regulatory oversight, regular data reporting, all sorts of things like that. So this new category of legal professional, so a non-attorney who can actually provide direct legal services, is one of the sandbox reforms. So CJAU is in the sandbox. Community justice advocates on the scope of legal help continuum kind of sit in the middle here. We have navigators who most of us, we can kind of identify potential legal issues and then give people access to resources or say, here's a referral, or I know you can go to the Utah Court Self-Help website and get some forms, get some information, but that's kind of where their help ends. On the other side, we have attorneys who are doing everything. They can help you with anything under the sun with a legal issue. Community justice advocates are trained in a specific area of the law, and they provide services just in that area. And they are supporting self-represented litigants. So they are there to help individuals with legal advice, with the documents. In some of our programs, they're negotiating with the other side. In some of our programs, they're sitting with them in court to help them through the process. so that they are not going it alone and they have information so we can kind of level the playing field and make sure people can meaningfully access their rights and understand what's going on so they're not left floundering. So we have three programs at CJAU. The first, and we'll spend most time with this, is our Certified Advocate Partners program. In this program, advocates are trained to be able to support individuals seeking civil protective orders or civil stalking injunctions. What that means in practice is they're able to screen cases, see, this is a good case, this is a case I can help with. They provide legal advice. I think you have a strong case, you're eligible for this order. Let's make a plan together. They're also able to actually draft the protective order request on behalf of their client, taking, here's the evidence, here's what you've told me, let's draft it. The client gives final review, client files it. And then they can also help the client prepare for court because court is not an insignificant thing that we have to come up against. And in this program, because of fabulous feedback from victim advocates in our program, we now have authorization to let them sit at counsel's table at the hearing and kind of provide promptings and guidance to their client throughout the hearing to help them get that order that they are qualified for. We have around 35, I want to say, active community justice advocates right now. A few more are finishing up training, and we train twice a year. And I will come back to that here in a minute. We also have a housing stability community justice advocate program. In this program, individuals are trained to be able to identify potential housing legal issues, habitability, repairs needed, utility overbilling, things like that. They're able to go through leases, explain those, advise on rights and responsibilities of the tenant and the landlord, help people understand their options, negotiate with the landlord on behalf of the tenant, help with the eviction process if it goes to that point, and again, sit at counsel's table if there's an eviction hearing. And then our last program is our medical debt program. We know that there are high levels of medical debt, and this can be crushing and create a lot of financial and housing and familial and job instability in individuals' lives. In this program, our advocates are trained to negotiate balances, understand and explain medical billing and explanations of benefits, and all of those fun insurance concepts, and then help negotiate balances, payment plans. Can we try to get charity care? Can we reduce this debt so it is not so crushing? They can also help with the collections and court process if it assists there as well. I like to show this flowchart. It shows how clients are accessing services. So while my agency, we are providing training, we're providing support, the client doesn't directly interact with us. The idea is, somebody is working at a domestic violence shelter. Someone comes in and staff recognizes this person is probably eligible for a protective order. Let's go have them talk to our CJA. That CJA screens the case. They have the authority to screen, accept it, deny it. Doesn't have to go through anyone else. They deliver the services. They have the authority and the autonomy to do that. And then at the end of the case, they do ask for some feedback. Advocates, to become a community justice advocate, they will go ahead and submit an application. They just soft opened this week, so that information is on our website, cjau.org. We meet with every applicant and their supervisor to answer questions, make sure expectations are aligned before enrolling them in the course. Advocates then engage in around 40 to 50. It can vary by program and also somebody's familiarity with the subject of online legal learning. We're going to talk about what does the law say, what rules do we need to know, what legal skills do you need to know, client counseling, legal writing, things like that. We then can certify the advocate, and then they are good to start delivering services. We do provide ongoing support. We collect data every month, which we report up to the sandbox. We provide every advocate with an attorney mentor to call when those fun, different situations arise. And then we also provide ongoing training, roundtables, and malpractice insurance coverage. Um, I'll go through this and then I'll ask if there are any questions. So yes, applications are open. If you scan this QR code, it should take you to the right page on our website. Applications for all three of our programs will be due in just over a month on July 24th. Contracts and paperwork are due Friday, August 7th. And then our housing stability and medical debt programs we know are going to start Monday, August 17th. CAP may start slightly later in the month, but we are finalizing all that information now. If you are not certified, are not in a place, but want to be able to refer someone to a community justice advocate, you can find that information on our website as well by just going to the Find Help tab. We don't have all of our advocates listed, just advocates who are willing to take those outside referrals, accept client calls for legal help. All right. I will now pause here. Here's my information. I sent Beatrice my slides, so these should be going out to you. Does anyone have questions that I can answer? I also see several of our DV in here, and they are also fabulous and can answer so many of your questions too. All right.
No question, but I just wanted to commend you for actually doing this project. It has been such an amazing resource to just have those extra bodies to take time to listen to folks. And so I really think it's such a great program.
Yes, we have amazing, amazing advocates. I would like to support and celebrate them all day, every day. They do amazing work. Um, Someone asked in chat, is there any consideration about additional compensation for CJA advocates? So CJAs are employed by organizations who are not CJAU. And so that is totally up to the discretion of the agency. We have asked advocates before if this did affect their compensation. And the answer is the lawyer's favorite answer. It depends. Some organizations have taken it into consideration because it is an additional credential, providing an additional level of services. Other organizations have not. All right. I won't take any more time because I know there's more fabulous presentations, but if you have any questions, please do reach out. Contact information was on those slides, or you can go to our website, and I will hang out for a little bit longer and I can respond to questions in the chat.
Thank you, Hayley. We appreciate your time and the dedication that you've given to the CJAs. It really is such a meaningful program. Thank you.
Yes, thank you so much. I just appreciate you coming and sharing. And I think it's so important for everyone to know about the program, know their options if they'd like to, become one of those certified advocates. So thank you. Thank you. Okay, so we are going to be for the rest of the time talking about criminal protective orders, which I think that the civil protective orders, we know there's a lot of complexity with that as well, but we wanted to focus today on criminal. So I'm going to have Rachelle start us off, just a little overview of what we're going to be doing today, talking about jail release agreements, pretrial protective orders, sentencing and continuous protective orders, criminal stalking injunctions, and then kind of going over some tips, best practices, and other code changes. Yeah, Tasha, did you have a question? Sorry, I didn't mean to cut you off.
No, sorry, you are totally fine. I was just wondering, oh, Hayley, it looks like she answered it, but I was just curious if there are any problems where advocates are housed in universities, because we do have our Office of General Counsel as well. So I was just curious if there has been any problems with advocates becoming certified to help with protective orders, and if so, what were they and how did they go about addressing them?
Yeah, so as I put in a comment, we do have three DVCJs who are at universities right now, two at the U and one at USU. I think specific questions like that often warrant a longer conversation, so please reach out to me about your specific university and where you are in the university, and we can definitely have those conversations.
Okay, perfect. Just email you. Is that best?
Yeah, that's
Okay,
perfect.
awesome. Thank you so much.
Great question. Thank you, Tasha. Any other questions for Hayley? Sorry, I realized maybe we didn't quite give enough time. Perfect. Awesome. So that's kind of our overview. I'm going to let Rachelle kind of talk a little bit about the VSE and the process of how we kind of got involved with the jail release agreement and things like that. So I'll let you take it away, Rachelle, first.
Perfect. Thanks, Vickie. I just want to start I will be very brief, so I'm only going to join you guys for a little bit. But for those that don't know, the Victim Services Commission is a statewide department made up statutorial, has members of law enforcement, prosecution, our coalitions, and our goal is to elevate services for crime victims. So, how this kind of came about is just a little bit of history, just because some of you guys are pretty young. I don't recognize all the same faces. I feel like you're either in this field forever or it's a forever turning over kind of department. But in about 2016, the state legislature passed a Senate bill that said alleged victim may waive in writing a jail release agreement. And that was pretty much as vague as it was, that they just can. And that kind of lasted for a little bit. And then in 2021, they clarified a little bit about what that waiver can cover, but it still never really said who creates the waiver, what does the waiver look like, who do you submit the waiver to, who lists it on file. I don't know if it was intentionally built pretty vague, which I love a low barrier thing, right? So if a victim's only option is to write it on the back of a napkin and hand it to the next person, then I love that option for them if that's that option. But what we're finding more often is that it was really confusing to victims, especially if we think about domestic violence. It often spans different jurisdictions. You know, the victim may live in one city, but work in another city and have daycare in another city, especially along the Wasatch Front. That when I worked in West Valley, we were having victims that were having multiple cases in multiple jurisdictions. And they were like, wait a minute, the waiver looks completely different here. And I submitted a waiver in this area, and all I had to do was show up or, do this. And so for years, we were hearing about kind of the frustration along these waivers. And that also was being heard by our legislators. And so in 2025, Senator Todd Weiler, he passed a bill that is like, look, agencies, you need to make this more clear to victims. They need to know exactly what does a waiver look like, where does it go, and we want that policy up on your website. And so how we kind of thought we could help out is, Vickie, maybe you can throw that JRA packet in the chat. But under the Victim Services Commission, the Domestic Violence Subcommittee, we formed a little work group. And we talked about kind of all the different issues that were coming up regarding these jail release agreements and the waivers. And we thought, well, maybe if we could just create a standardized one that's completely voluntary. So the law still stands and it's just a waiver. But we knew a lot of agencies didn't have them or they were creating them on the fly and they just needed some help, that we would just kind of give them a little head start of like, here's what it could look like. And so we created just this packet that we can distribute. This is kind of one of the first places it's being distributed to victim advocates, which I think is the most beneficial. We're the ones that are able to kind of massage that into different policies. So we're hoping that you can take a look at this packet. It's a new resource, and so we want eyes on it. We want feedback. We want criticism. If it's, if there's changes that need to be made or if it's not meeting the needs, then we want to know it. It's a living document. But then we're going to distribute it to law enforcement, to prosecution, to the jails as well. So if they do not already have a waiver or an agreement in place, they can use this example to create one of their own. And then they can follow the mandate of actually having their policy up on their website. So that's kind of a really simple kind of information on that. Again, our goal is just to create less confusion for victims, more consistency throughout the system, and just kind of more clarity around that. But it's a voluntary service. It's just meant to be helpful. And so if your agency already has a waiver that's working well, ignore this whole part of this presentation, or actually look at our waiver and say, hey, ours is working well and you're missing X, Y, and Z. We would love that kind of feedback as well. But if you looked at your agency and you don't have a waiver that you're loving and you feel like you could benefit from this tool, please feel free to use it and ask questions as needed. And that's all I have.
Thank you, Rachelle. And I think it's been interesting to see that starting from our discussions that we were having with our state-funded criminal justice advocates, we were seeing those gaps, or had kind of got a better picture of how the different counties handle the jail release agreements and waivers. And so that was kind of that forming of that group. So it was great to see how on the boots and ground, people working with victims can bring those issues to the VSC, and we can make some great changes within the Victim Services Commission. It's been really wonderful to see how many areas in domestic violence, child abuse, sexual assault, that we have already been able to see those changes made. So with some of the questions in the chat, just wanted to get to those before we kind of jump into the information. And then I just wanted to show the JRA packet and kind of so you can know where you're navigating. This has been a question that has come up that Joanne asked of who's able to get and authorized to give a copy of the jail release agreement. I know that in some of our counties, especially those along the Wasatch Front, where the jail is issuing the jail release agreement, that there have been issues getting an actual physical copy. The statute is a little more vague, like Rachelle was saying. We have kind of that vagueness in regards to waivers and on the jail release agreement, where it does say that the victim should be given written information on the jail release agreement. But in contrast, we have with pretrial protective orders, sentencing, and continuous protective orders, it says that the court shall give a certified copy of those orders to the victim. So the jail release agreement just says they're supposed to be given written information. That is something that the VSC, the Victim Services Commission, is aware of, and something that we're hopefully going to talk with legislators this next session and see if some cleanup language can be there, because I know that we've had some issues with the jail saying that they cannot give a copy of the actual order to the victim because it's entered into UCJAS. When I have talked with Amy Hernandez with the courts, the actual physical copy of the order, so let me kind of show you the packet here really quickly. And B, tell me if it's not showing on your screen. But if you see the jail release agreement, we have added on our template. Sorry, let me get that full screen there. We have added to the template. Oh, sorry, this is the waiver. Let me get to the actual jail release agreement. That one of the check boxes is to give a copy to the victim. That is our hope, that can become the best practice, that the victim is receiving an actual copy of the jail release agreement, what the defendant signs. And so with Amy, when I checked with her, and other people can correct me if they've gotten different information from her directly, but she said that they can't pull it necessarily specifically from UCJAS because a lot of advocates don't have access to that. So advocates usually can't necessarily give a copy directly from UCJAS, but the physical copy that is signed is supposed to be sent to the arresting agency. So sometimes those are uploaded to the police report or things like that. So there can be those ways that a victim can get a copy. If you're having issues with that, I'll put Amy's email in the chat as well, but that is something that is one of those areas that we have seen a lot of confusion and breakdown of information in certain jurisdictions where getting an actual copy of the order has been difficult for victims. So we're wanting to find ways that we can work with that before we can give. Sorry. I just realized I didn't close it. Thanks. No, you're good. That we're wanting to kind of fix those barriers that are happening with the victim. So if you're working with UCJIS on how it's entered, because it looks to be one waiver per adult victim, they're not entered that way. So when you're working with UCJIS, yes, it does have to be one order per case, and we'll kind of talk about it in our best practices. But a victim that is an adult for the waivers, if you go back to the waiver, where we were having issues is that maybe like what the victim wants to waive the adult victim, but there's multiple adult victims in the case. You can run into that issue that the waiver is confusing in the UCJIS. If there's multiple adult victims in one case, because we'll talk about it a little later too when we get to that, but that is something, and we'll also be talking about with it in regards to jail release agreements for children as well. But kind of wanted to answer a few of those questions. So in that packet, you'll see there is a template. Like I said, we are open to feedback. We do have some best practices in that as well that you can look through. If you have suggestions or things that you would want to add as best practices or to resources, we would love to learn that and hear about those. This has been an ongoing work in progress for sure. So those are some instructions, some additional resources. No, they don't get each other's contact information. They would have, the waiver is just that usually, so if it comes to any other criminal protective orders, they can only have one actual order entered into UC just per court case. And we'll kind of talk about that. We'll get to that slide, but and so you can have multiple victims listed. The way that the court clerks have gone around that is to one order, they'll upload a PDF of what that protective order looks like, a sentencing or continuous protective order. That would be something that is then uploaded into, and they have multiple pages, but they have each victim. The one caveat with that is that the orders of protection, so the no contact, stay away, things like that, they can't be item or unique to each victim. So they have to either have all the same orders of protection. So that can be sometimes issues with a criminal. So we'll talk a little more about that as well. For the JRA list, the victim does, the contact information is listed on a jail release agreement. For them to be able to have the order stay away, they do need to know who the protected party is. So I'm not sure if I'm understanding your question, Ruthie, but if you want to unmute, you can ask it as well.
Yeah, my question though is, so you have multiple adult victims on one case, the JRA will list them and it will have that contact information. So if you're providing a physical copy, how is that being navigated?
They would redact the other, they should, that's best practice would be that the other victims' names are redacted.
So is the jail redacting that? Because I haven't seen that.
I don't know. Okay. But that would be the best practice, is they're redacting other names for the jail release agreement. But that could be another issue that we're bringing to the legislators. It's a great one. I'll put that on my list. So, okay. So I kind of wanted to start with like a scenario. We're going to come back to the scenario throughout of how we're going to progress this case. So we have Rose, who's a 32-year-old female that was assaulted, punched and held down by her husband, Gene, in front of their children. I switched the genders on that accident. Liam, 3-year-old, we'll say it is actually Olivia is a 3-year-old female, and Liam, who is a 1-year-old male. Gene was arrested and booked into jail on assault, which was a Class B misdemeanor, unlawful detention, and 2 counts of domestic violence. One thing to note, we'll get back to this in a minute, but in the presence of a child. So officers informed Gene that he cannot contact Rose while in jail directly or indirectly. She scores a 6 on her lethality assessment with answering 2 yeses to high-risk questions. That Rose is concerned about her safety if Gene gets out of jail, but also concerned about her financial security with him in jail. So if you were responding on scene, maybe either you're responding physically on scene or you're talking to that person on the phone, what are some things that you would want to first discuss with Rose? Kids were present, so yes. What are some things we would want to first be talking to Rose about? Yeah, some safety options, possibly shelter, right? What are some safety? And we may want to talk about protective orders, right? Civil or criminal. How do we maybe address her concerns about her financial security? Yeah, medical. Yeah, she needs medical attention, safety planning, and shelter for sure. What are some of those things that we ask, when our shelters are getting the call based on the lethality assessment? Maybe what are some things that you often offer when you're getting those lethality assessment calls to the victim? Yeah, asking what their financial picture looks like. What are the actual concerns? I like that, Lori, like getting a better picture of what's going on. Get her in contact for resources for financial assistance programs, what supports are available. Yeah, seeing if she's got family, maybe somewhere else that she'd feel safer if she's not wanting to go to shelter temporarily. Yeah, great. So we have that Rose, there has been one of the things that a lot of people don't realize is in the statute is when someone is booked into jail on a qualifying offense before a jail release agreement is even issued. The officers do have the obligation to inform the arrestee that they are not to contact the victim directly or indirectly before even a JRA. So yeah, I love in the comments too, validating the concern she has while giving her the education and resources available to her in her case. Emergency shelter, civil protective order, basic needs. Yeah, maybe making sure that, maybe they need assistance with food or housing. On scene would be immediate safety plan. If there is a JRA in place, then we would explain that and then continue with other resources. Yeah, great, Alicia. So there is a lot of, I know with presentations, you don't want too much words, but I wanted you guys to have the actual statutes and the words that are from the statute. So this is all hyperlinked and it hasn't been uploaded to today's folder. If you checked like an hour ago, it wasn't there, but it is there now. But upon arrest or citations, that's what a lot of people are confused with or there's misconceptions about jail release agreements is the person has to be booked into jail. They do not. It is if they were issued a citation or arrested and booked into jail. So if an officer cites and releases that, they can still then, the officer would be the one issuing the jail release agreement. And we do have, and I'll get to the next slide, qualifying offenses. So they're cited or arrested for a qualifying offense. And before the individual is released, the individual may not telephone contact or otherwise communicate with the alleged victim directly or indirectly. And then the individual may not be released before either the individual signs a jail release agreement or is seen by a judge or a magistrate. So that is usually that condition to be released from jail is they have to sign a jail release agreement or a judge has agreed to release them. And usually there is release conditions as part of that. So what is a jail release agreement, right? The one really exciting thing is we have added to our qualifying offenses this starting May 6th. So now with the qualifying offenses that you can get a jail release agreement is domestic violence, offense against a child or a vulnerable adult, a sexual offense, and now we have stalking. That's the newest one. That is something that we were really excited to get added. The things that it doesn't include under those sex offenses is lewdness involving a child, and enticing a minor. Now, the enticing a minor is only in place that it doesn't include until January 1st of 2027. With House Bill 90, that those changes will go into effect in January. And so the enticing minor will now still, that will go back to being included in the sex offenses for a JRA. But lewdness and involving a child are the two sex offenses in that section that are not included. The conditions of a jail release agreement is that the arrested person will not contact the victim by phone, email, or other means directly or indirectly, threaten or harass the victim, and enter the victim's home, temporary or permanent residence, so they may be staying with someone, that would be still considered a stay away order. The jail release agreement is meant to be a very short-term temporary order in order for the victim to have other safety measures or for us to proceed with our criminal case. So that can be getting out of the shelter, getting a civil protective order, those other things. So that jail release agreement is in place until midnight of the initial court appearance, or the prosecuting agency declines to file charges, they file a declination, or 30 days have passed since the initial arrest or citation. Yes, so if there is that the initial court hearing does not happen within those 30 days, it will expire. So this becomes really confusing, for victims. So that is something that was one of those issues where I had a case before they fixed this, that the victim didn't want the jail release agreement, had done the waiver, but the full, we didn't actually have a jurisdiction for the waiver to go to waive it because he was booked, but then charges took, and he was booked, but then charges took more than 30 days to be filed against the person. And it took longer. So we had, at the time, the way the waivers worked and things like that, there was no jurisdiction for her to waive it, and there was no way for us to do that. So that's part of the fix, is that it does make it so the prosecutors' agencies do have to file charges or decline to file charges within those 30. They're supposed to do those within that 30 days. Yes, so the perpetrator does have to stay away the 30 days if until there's either a declination or the 30 days have passed if there hasn't been an initial appearance, unless the victim were to do a waiver, then that can't be in place. So hopefully that answered your question, Laurie. The releasing agency, so that releasing agency typically is the jail if the person was booked, but it can be the law enforcement agency if they were cited. They are supposed to notify, if they're their own law enforcement agency, right? They're supposed to notify the agency, the law enforcement agency that cited or booked the person, of the release and the conditions of the release and any available information concerning the location of the victim. So if the releasing agency knows, maybe the victim has called them or called the jail or things like that, and they know information, they should be giving that to the law enforcement agency so that the law enforcement agency can notify the victim. The releasing agency is actually the person that is responsible for making sure the victim receives notification. A lot of times, the way we've seen that is that the jail is notifying the law enforcement agency and the law enforcement agency is notifying the victim, but it is on the obligation of the releasing agency. They should be giving the arrested or cited individual a copy of the jail release agreement. And then at the time of arrest or citation, the officer should provide the victim with written notice containing the release conditions and the notice that the alleged perpetrator will not be released before appearing before the court unless the perpetrator enters into a jail release agreement or the judge issues a jail release order with release conditions. So that's one of those things that is usually a condition of the person being released from jail, especially like on our scenario, right? It's a Class B misdemeanor. Likely that person's going to release fairly quickly, but they would need to still sign that. So how soon can a victim apply for a protective order? If the court is after that 30 days for the JRA, can they overlap? Yeah, so civil protective order, they could go, it's the next business day and apply for that. There's not a time limit of when they can apply for that. Usually if it's been a longer time since the last incident, the courts may want to know why they're fearful now. So if you had someone coming, there was an incident 3 years ago and now they're getting a protective order, there would be question with that, but there isn't. For a civil protective order, they could go to the court immediately. For the criminal, it would be based on if the criminal case is proceeding. I hope that answered that question. So it would be they can go and apply for a civil protective order and request that civilly through the district court's processes. But if the court case is not going to be continued, if there was a decline of charges or we're past that 30-day mark and charges still haven't been filed, that would be different. Yeah. So the civil protective order, they can go and request even if there is a JRA. Yes. Okay. So kind of back to our scenario, we have Rose calls the crisis line at 2 a.m. and is terrified. She received notice from the officers that Jean was being released from jail, and that a jail release agreement was issued, but Jean texts Rose that he was on his way home. She asks, wasn't he ordered not to contact me? How would you respond? How would we be navigating this? Yeah, so we'd want to notify, right? We'd want to make sure, tell her to call it in as a violation. Yeah, Alicia, that's a violation of that, right? That was part of his conditions not to contact, unless she had signed a waiver, which likely if she had signed a waiver, she's not going to be calling you at 2 a.m. asking why he's contacting, right, from getting released. Eva, on your question, would this be the same process if the victim, I think you're meant to say is a minor, but the defendant is an adult. So we'll get to the minor, all the criminal protective orders in regards to minors. So I will come back to your question. Yeah, so we would want to let them know that yes, that is a violation, that we would have that the jail release agreement. We may want to call, dispatch to verify that it was issued, and they can check on, officers can check on CJAS that it was issued, and then encourage her to report that violation. If you're a system-based advocate, you may also, let them know that was the call you received. If you're a nonprofit, I would then, be encouraging them to call the jurisdiction where the crime happened. Okay, so let's say that the victim, in this scenario, Rose didn't do a waiver. She wanted the no contact, but we have a victim that doesn't. So an adult victim may waive the no contact order and the stay away order of a jail release agreement. This has been a misconception for a lot of people that if they sign the waiver, the jail release agreement is just removed completely. That is not the case. It will still stay on the system until that initial appearance, decline of charges, or 30 days have passed, with the order of not to threaten or commit domestic violence or abuse against the person. So that order cannot be waived because it's a crime, right, to threaten and harass or abuse another individual. So that's often sometimes, I had a case where the defendant, he was trying to be really careful, which I was, that's probably, he was advised by his attorney. He's like, well, it still shows on the system, so I am not going home. And he was given a copy of the waiver and he was being extra cautious, which I appreciate. The victim was very upset with me because she had signed the waiver. But that was, again, his choice because it was still showing on the system because of that in one order. So the 3 places that a victim can do that waiver is in person. So this is one of those that they can't do a waiver over email, and it does have to be written. Like Rachelle said, it's really vague of what that written means. Most agencies do try to have some type of written waiver form that they can fill out, but it is meant to be that you can't just do it electronically. That the victim can appear in person to a law enforcement agency, a jail or correctional facility, or a court of jurisdiction. One thing that Amy Hernandez has asked me is that it is in the statute that they can go to a court to waive it, but the courts a lot of times have a lot of difficulty with that because they haven't received the case a lot of times in that time that the victim's seeking a waiver. A lot, maybe the next morning or things like that they're seeking that waiver. And the courts don't have the knowledge to know conditions about the minor or whether, there's other elements of the case that involve that waiver. So they usually will still refer the person back to the jail or the law enforcement agency. It's more maybe the court could get involved if it's been a longer time or we're having that issue. But if they don't have a case sent to them, they often aren't able to put it on the system because they don't have the information for the case. So that's one of those areas that I would check with the processes in your jurisdiction. But a jail or law enforcement should have the capability and have the ways and mechanisms and policies. Like Rachelle said, Senate Bill 83 from 2025 does have that police agencies are supposed to have a policy in place and have it on their website. We have had an intern, our interns have gone through and checked every law enforcement agency website that we could find and get access to. Some of our smaller ones it was hard to find. And I will say that most of our agencies, it is very difficult if we were able to find it and it was buried within their maybe domestic violence response policies and wasn't very easy to find their policy on jail release agreements and waivers. So that is, if you aren't sure if your agency has it on your website, check. It is supposed to have been done by January of this year. And if you do find it and you're like, here it is, here's the direct link, we would love to have that. We have a tracking sheet that has all the links that we were able to find, but we were unable to find from a lot of agencies. We like having victims come to the police department instead of the jail because then we get eyes on them and check in and safety plan as they come to waive. Yes. So, and the one thing to know, I know there's some people have different views of whether a victim should be able to assign a waiver immediately on scene. They have the right to that they have the right to be educated on the waiver, and be given written information on a jail release agreement and a waiver. So a lot of people will have that in their domestic violence brochure, but those other qualifying offenses often don't get the right education or information given to them on, sex offenses and now stalking offenses, abuse or violence towards a child or vulnerable adult. Those ones often don't have that written maybe as clear. And so I would highly recommend looking at your policies and seeing if you have that as well. It's a good question, Alicia. This is one of the reasons that we have tried to create the template to create a little more standardization. The VSC doesn't have the authority to standardize it. But yes, I would personally love to see it be standardized, that it is the same form for the waiver and for the jail release agreement across the state, because there is so much confusion. But yes, I would love to see that happen, but that has been one of those difficulties. So that is one of the reasons why we created the template, to create a little more standardization. Some of our rural areas that, it's a really tiny law enforcement, like there's 5 officers for the entire county, had never even heard of a waiver. And that was really concerning, right? So we definitely have done a lot more education and we're continuing to provide that. And we'd love to provide education to the department. So the where the waiver needs to be sent, you can have the person that's signing as a witness does need to be, sorry, let me grab it. It can be someone from the agency. Sorry, where did it go? I had it on my other screen. Sorry, there we go. So with the waiver, you'll notice here the signature, and then it's a criminal justice agency representative signature. So it does have to be that an officer is putting it into CJAU. So there isn't a specific email address that would be handled internally. So I would check with your law enforcement agency if maybe there's a sergeant or something like that you're supposed to be sending that. But this is, it does have on our template that a criminal justice agency representative. So questions, barriers to the standard form. Agencies don't like to be told exactly how to do something in statute. That's often why statutes are left vague so that they can make their own policies. I think that's been some of the barriers, but it has created that confusion, especially with jail release agreements, since they're so short-termed. It creates a lot of confusion in that time. They're meant to be that helpful piece so the person could get other protections, but there has become a lot of confusions. I would love if there's other people that feel like they can help elevate this to become standardized. We'd love that. It's just been one of those things that we've been trying to slowly create avenues and resources for people to create a more standardized form. And we've had, in our JRA work group, we had law enforcement, court, prosecutors, and victim advocates on our JRA work group that created the form. And so, but we would love to, like I said, if there's hey, this doesn't quite make sense, or this logistically doesn't make sense, we would love to see that feedback too. It has been one of those difficulties. So I'd love to see it standardized, but me as a peon in the world of code and statutes, I've not been able to make that. But Um, yes, so I think it would be, Vickie, it would be helpful if we had a list of requirements for agency like this requirement being listed. Is there one? Yes, I mean, there's a ton of different requirements, obviously in statute, but this specific one with Senate Bill 83, we have been trying to provide a lot more education. This is one of the reasons we did this presentation, but also I've been working with Trent Dresden to try to get the word out to our police agencies as well. And that was one of the reasons we created a tracking sheet and things like that. So unfortunately, there's like a lot of the different statutes that change every year, and that's why we tried to do the legislative update we did a few weeks ago and things like that. Um, but I can try to work on a list for you, Karina. So, okay. So in regards to a jail release agreement waiver with children, this is one of those areas that has been confusing, or the releasing agency or the agency that's doing the waiver says, we can't remove children. There is the caveat with it that obviously if the person requesting the waiver is the arrested individual, even though they're the parent of the children, I'll add a copy of I can add the tracking sheet into the folder, or at least I'll put the link in the chat for you, Ruth. And it's not to like call out agencies that don't have it. It's just more like we couldn't find it. So like I said, it's just we couldn't find it on people's websites. But it's not to be like shaming anyone that doesn't have it, just to be clear. So one of the things is if the parent is arrested and it's their children, they cannot do a waiver to remove their children. The child has to have not suffered bodily injury as a result of the crime. In order to be included in the waiver, these are the things that have to have taken place. So the child is not injured or was not injured during the crime. The child wasn't the one that summoned for emergency aid. So they weren't the one that called 911 or called, maybe a neighbor to come and help. They weren't the one that summoned that aid. And this one's always worded really weird in the statute. So I highly recommend reading the statute in this piece too. But the arrested individual did not threaten the child with bodily harm between the time they were arrested and the jail release agreement was issued. So let's say like officers were on scene and they arrested the person and booked him into jail. The JRA may be issued once they're getting released, but maybe that parent called their 17-year-old child and threatened them. That would be another condition that you could not waive the children for a waiver. So that one, it can be really hard to know if that actually happened if the child didn't disclose that, or we maybe don't have it on a jail tape or something like that. So that's one of the reasons the courts also have a harder time with the waivers, is they don't usually have this information about the children, so they wouldn't remove the children from the waiver from the order. Any questions on that? I know that that's kind of really confusing. And how is the jail release agreement waiver process going in your area? Have there been a lot of hiccups? Do you feel like it's running smoothly in your area? I always love to hear good, bad, that feedback.
Can I just add something real quick, Vickie?
Absolutely. Yeah.
So real quick, in addition to what I just messaged you about the list, I did take notes on everything from the last Swavo series where we went over all the bills, and I sent it to my chief. It's kind of hard, and I don't know if everybody else has the same thing in their offices where your chiefs and officers expect you to know, like, oh, you should know everything about the laws. And I'm like, okay, last I checked, I didn't go to law school. So I'm trying to read the laws and understanding what I need to put in place. So it's kind of like everybody just expects somebody else is doing the job. So I just think it would be so easy if we kind of had a running list and of like, hey, you need to make sure this is either policy or best practices. And then I can move forward with making sure that's implemented. Just that would be helpful. So, okay. And then in regards to the JRAs, I just had one last week, and I told my victim after I left, I registered her for Vine. He was in custody. And in the JRA, it did state that he could not contact wife or children. And somehow my understanding is the officers can, I think, electronically block the number so that they cannot contact that physical number.
From the jail, they can.
From the jail, yes. And so he ended up calling her She didn't pick up because I did tell her if for any reason he does try to contact you, I don't want you to call. I don't want you to pick up a call from this number. And she said, well, what if it's them telling me he's being released? I said, that's not going to happen. That's what Vine's for. I've yet to have the jail contact a victim directly and tell them. I've had them contact law enforcement and say, hey, I'm letting you know that I know you guys just arrested him. He bailed out. It's only been 30 minutes.
Right.
And so anyways, that did end up happening. And I was kind of surprised. The jail said, well, we can file charges, or you guys can file charges for violation of the no contact order. So
Yeah, and that has been one of those issues. So usually the releasing agency has the responsibility, but usually that responsibility, they will call the law enforcement agency and say, hey, this person's released. And they ask the officers to notify the victim, because the jail doesn't always know the victim's information, or they may not contact that. So I haven't usually seen the jail being the person calling either. It's usually they have called the law enforcement agency, and then the law enforcement agency is informing the victim of that release. If you're in that period of like past 96 hours, where maybe we don't have a case filed or things like that, that's sometimes where balls are dropped in notifying the victim of that release. That's where I have seen issues, or have had like people complain or things like that, where in that first 96 hours, the jail is really good about calling the law enforcement agency, letting them know. And a lot of our domestic violence assaults that are class Bs, they are going to get, they are going to bond out pretty quickly. But that they do still have to agree to sign the waiver. If the defendant is refusing to sign the jail release agreement, that is going to impact their ability to get out of jail. So that's one of those things that either they have to be seen by a judge and the judge makes a ruling, or and they do a jail release court order, or they are going to sign the jail release agreement to be able to bond out. So that's one of those caveats. So just kind of lots of questions. Please throw them in the chat. And my internet is being like slow on the one end, so sorry if I'm freezing at all. If you want to put a link, just a viewable link, Beatrice, to the JRA tracking sheet, or if you wouldn't mind doing that, that'd be great. Yeah, I think, Alicia, this is the feedback we're getting a lot, and this is one of the reasons we wanted to have this discussion about jail release agreements and criminal protective orders, is that lack of consistency with other agencies following the law differently, and the court hearings not happening in that 30 days. Yes, and Ruthie, I agree. One of the biggest issues is the one JRA for multiple victims. So this is one of those things that Amy Hernandez is well aware of, these difficulties with criminal protective orders, but it comes from the FBI. And the way UCJAS is structured, and she can't change it. So unless the FBI actually changes it, they can't change it. So that's one of those really frustrating things, that we can't fix it because it's coming from the FBI. Just to know. Thank you, B, for putting that in there. So kind of that difference between a jail release agreement and a jail release court order. When I talked with Amy too about this one, these ones are a little less common just because they are that really short term, and usually there's going to be a pretrial protective order instead of this. But this is often when maybe we have a bail hearing that's not that initial appearance, or things like that they were addressing that they may do a jail release court order, or the person is refusing to sign a jail release agreement, and the judge is going to be seeing them on that. So we have someone maybe booked, and they're going to be seeing them on that. Have you guys seen jail release court orders issued very often? Have you had success with those? Love to hear that in the chat as well. So the same conditions can apply as a jail release agreement, but it's issued by the judge. So the victim cannot waive this. That does not have a waiver attached to it. It is issued by the judge and the magistrate. It's usually issued by the court, like I said, either addressing bail or release before we're going to have the formal court process going forward. A pretrial or sentencing protective order issued does supersede any jail release agreement or jail release court order. So maybe we had, the no contact and the stay away and all of those orders in the jail release agreement, but maybe in the pretrial contact, they're allowed text contact. Now that order supersedes what was issued in the jail release agreement. And then if the court dismisses the charges for a qualifying offense, the court shall dismiss the jail release agreement or the jail release court order. We can't have an existing jail release agreement or jail release court order in UCJAS if there's no case going forward. And then again, the victim cannot waive this. So question in the chat, is the suspect have the right to show up to court before the initial appearance and ask the judge to remove the JRA? I believe they can request to be seen. So yeah, they can request a hearing in regards to it, but they don't. It would be up to the judge whether it's removed or not. Beatrice, do you have any other additional info on that question? Sorry, put you on the spot.
No, it's tricky just because it has happened in the past at West Valley when I was there. They would show up and, Mariah, you know how we were all in the same building at some point. So the judge would tell the prosecutor, they'd call us and we'd try to make that phone call. But just kind of depends on your judge. Usually they will just extend the hearing and schedule it for a further date. So that way the victim can be notified and have an option as to what's going on. Otherwise, I think it might even depend on the prosecutor saying, halt, we have these facts of the case. We'd like this protective order to remain until we're able to speak to the victim, depending on the circumstances. I've had a judge be like, no, you can't, remove it. We're going to if we arraign you, I'm going to put a court order still. So that way you're still not contacting the victim or going back to the home. Just because the victim ultimately, especially depending on the charges, if it's a felony case, they have the right to, be part of this proceeding and be notified. So I feel like it's a twofold answer. I wish I had more straightforward, but as we've already mentioned, jurisdictions, individuals, they all run a little bit differently. And our goal with these new processes is that we're all starting to get aligned and have a shared common knowledge so that we can hopefully start standardizing our practices statewide.
Thank you, Bea. That was very eloquently said, much better said than I could. So it is one of those interesting things that the JRA, kind of that back to that conversation of why can't we get it standardized, because all of our other criminal protective orders, we do have a standard form. So this is where you will see what the form looks like. This is what the courts are filling out or putting onto the system so that we have our requests for the pretrial protective orders as well as for, criminal stalking injunctions, requests for our continuous are all here. And then you also have the actual order of the form. So the images you're going to see on my slides come directly from the Utah courts. I will put that link in the chat to you so you can see all of those forms. So if you maybe have a case where there hasn't been a request for a pretrial protective order, maybe there's some issues with the prosecutor getting in contact with them or things like that, there are the forms on there for the victim to fill that out, and the victim advocate, system-based advocate, can get that to the prosecutor that the victim is requesting a pretrial protective order if the courts haven't already issued one. And just so you guys know, all of the codes are hyperlinked in the gold underlined code. It is hyperlinked directly to the statute. So for pretrial protective orders, they are issued for qualifying offenses. Those are the same as our jail release agreement. So stalking is included now in that. So they can be for our domestic violence, abuse of a vulnerable adult or child, sex offenses, and stalking. So that qualifying offense applies to all criminal protective orders now. Well, it always did, but we've added stalking now. Sorry. The court can consider the results. This was something that as I was rereading through the statute, I didn't realize this was added a couple years ago, but the court can consider the results of any relevant lethality assessment that was conducted in accordance to 7736 2.1. So that's something that I think that can be helpful if we are aware that there was a lethality assessment and the courts do have that information. That is something that they can take into consideration when deciding whether to issue a pretrial protective order. And this can be issued at any court hearing where the perpetrator is present. So sometimes you have maybe some of your other hearings that might be like a motion hearing or something like that, where it's just the attorneys. The perpetrator does need to be present. Yeah, that's one of those things that the lethality assessment doesn't get to the judges unless it's provided by the prosecutor. So that's one of those things where I have seen that there's differing opinions on whether the court should see the lethality assessment, but that is something that the courts can take into consideration when determining if it meets the criteria for a pretrial protective order. So that can be something too that we try to help make sure our prosecutors maybe get that lethality assessment that was administered by law enforcement officers on scene. It does have to meet the code requirements, which is the lethality assessment protocol protocol. Okay, so how have you guys seen our criminal protective orders interact with civil protective orders? What have been some of the barriers or issues or gaps you've seen? I think this can be one of those things that is often really confusing for victims when they have a civil protective order and there is a concurrent criminal order running as well, because they're handled in separate courts, right? But just things to note with the protective order or pretrial protective order, the court can include additional provisions that are on the jail release agreement. So these are things that they can include. They can obviously order the not to threaten or commit violence against a person or designated family members or household members, to not contact the victim directly or indirectly. They can also order to have the person removed and excluded from the residence, from the victim's residence, so that they can have them that stay away order, but also that is that eviction essentially that we also have in our civil protective orders. They can have that they need an order to stay away from the victim's residence, school, work, or other specified locations, and order for any relief that the court considers necessary to the protective order and for the safety. So they can add additional things to that. They do need to identify and require an individual designated by the victim. They can also, not require, they can have someone that is designated to be a communication between the victim and the perpetrator. They can also order for the perpetrator to participate in an electronic or other type of monitoring program, which I thought that was really interesting. That was one I hadn't read before. And then if the alleged victim and the alleged perpetrator do share custody of one or more minor children, they can order for indirect or limited contact to temporarily facilitate the parent visitation with a minor. So they can make those exceptions. Often we'll have maybe that they can text or email, so there's a written communication about children. So that can be part of the pretrial. The one very big difference between a pretrial protective order and maybe, let's say, a cohabitant civil protective order, the criminal courts cannot order any custody. They can't order any spousal or child support or anything like that can be ordered in a civil. So they can order the way they communicate about their children, but they would not order any sort of custody for that child in regards to that child. The court should determine whether to allow a provision of a way for that person to transfer their personal property. So often this looks like officers present while they remove their personal belongings or remove their belongings, which is very similar to our civil as well. Just in the chat too, we recently learned, I saw that when the criminal protective orders are typically not as tailored as the civil, which has caused some conflict, in second district. And that's one of those things where we can have conflicting orders. If the court does order that removal or exclusion for the perpetrator to leave the victim's residence, they also should include that the perpetrator cannot terminate utility services for 60 days, and that they can also order that they restore utility service to the victim's residence if they had interfered or stopped it. And the court can include provisions for which who is responsible for paying utilities as well. Okay, so kind of back to our scenario with Rose. So the court does issue a pretrial protective order at the arraignment. The court orders that contact about the children to be handled through a third party. But Rose has also been granted a civil cohabitant order, but she's allowed to text contact between the children in the civil order. So which order for contact about the children should they follow? How would you guys resolve this? This is something Alicia mentioned in the chat, being that issue? What are some ways you guys have found workarounds? What is the order you guys have indicated to victims to that supersedes? Okay. So you've indicated civil family court. And this is where I think communication is so key, is letting the judge know, hey, there is a civil protective order and they've been ordered that they can allow text. Can we add that as a provision to our criminal so they match? Because you can make modifications to your pretrial protective orders, right? I've told victims that the civil carries more weight. Our judge in Sandy usually has criminal orders follow civil orders anyway. Yeah, a lot of times too, they'll have a provision that contact should follow civil. Usually my understanding is that the most restrictive order is what is the order they should go by. So in this case, we have right now that the criminal one says it's handled through a third party. That's the most restrictive, right? So until we can get a correction in the criminal one and get that clarification, the safest way to be people are abiding by the order is the most restrictive, which would be the third party. But if you do have in the order that a judge specifically writes a provision that contact that is deferring to the civil, then that's where you would be abiding by the civil. The last direction we received was to go by the most restrictive. Yeah. So I think that that's really important to you, Alicia, that however most law enforcement don't have the time to dive into this while on scene. Absolutely. That's where we're limited, right? When we're in the criminal case, that's where that communication can be so important, that we're checking with our victims when we're issuing, that we know a pretrial protective order is going to be issued as part of the court case, that we're asking if they have a civil, or we're looking on exchange to see if a civil one is ordered, and we see that the orders are different, reaching out to the victim because maybe that civil one, that communication maybe actually has been really aggressive, and now we are learning about violations of the order, right, or something like that. So that's where that communication can be so vital for them. But yes, it is that's been always my knowledge and direction that's been given to me, is that you abide by the most restrictive order. So if the civil is more restrictive than the criminal, you're abiding by the civil. If the criminal is more restrictive than the civil, you're abiding by the criminal. So great discussion. Okay, so sentencing protective orders. And there's a lot of confusion between sentencing and continuous, so we're going to talk about it both. Is there any questions though before we jump into our sentencing and continuous about pretrial or jail release agreements or jail release court orders? I'm loving the chat and the interaction we're having today.
Vickie, this is Ruthie. So I had indicated, like, similar to Sandy, our judges defer to civil. They view the PPO as a temporary and either
A temporary fix, yeah.
Yeah. So, but I did have the question. So I have heard most restrictive, but then I think for us, like I said, so is there any legislation or statute where that's coming from? Or because I'm getting this vibe of this is what I've heard, or this is what, we've been directed, or, that's best practice. But is there anything in writing or legislative that says most restrictive, and that so that we know that if there is a provision in the PPO that is more restrictive than the civil, that we need to amend the PPO, which one would need to be amended in what way, that would, what's superseding, I guess.
I could not name a specific statute. That's just what I've been told by attorneys. In regards that you abide by the most restrictive, but I will find out and include in like a follow-up email or in our next training. I can give you guys an update on that. I'll check with some of our partners, our attorneys, if it does have that specific of like where it has a statute of which order supersedes or which, handling. That's just what attorneys have always told me.
And I've heard that too, but then like I said, I know our judge, but he's also a former prosecutor, is like, knows and indicates I'll defer to civil family court. But yeah,
Yeah.
I just was
And I
wondering.
think that that's best practice. I think a lot of times because there is a lot more movement, maybe with the civil, you're going to be going through a divorce case that may modify your civil protective order or things like that. And I think hopefully judges are seeing that maybe that communication about the children needs to be fluid and may have to be altered or changed. And so I think a lot of judges having that practice is to defer to the civil so there isn't the confusion in regards to contact about the children. Um, I think that creates a little more clarity for the victim that they aren't trying to look at which one they're conflicting with. But that is also where we can, as advocates, get that maybe clarification of like, hey, their civil order says this, we're now ordering something contradictory. And the judge could then say, like, no, this one supersedes. Like they could say that out loud in the case, or they could say, this is why we're ordering something more restrictive than what's in your civil. If they're not aware, they're just going to go by what's kind of standard, right? If they're of what's in a standard pretrial protective order. But maybe if we're saying, hey, the victim has already gone to the civil protective order process and they've had a hearing and they have a commissioner that has ruled on this, this way of contact that they've been allowed in their civil protective order, can we match that? I think that's going to be your best practice there.
And I do know that these forms require or notice of the additional cases, which include civil protective order or family court cases. And I think probably to address this, at least in part, this specific issue. So I know that they're supposed to be included on there. I just didn't know if there was anything like in statute that says least restrictive, or if there were, you didn't have a judge that included that in the order. Um, uh, per policy, like if we do want to have, where we could point to for that.
Yeah, no, and I think the other kind of argument I guess you could have too is in the criminal order, it's a judge issuing it. In a civil, it's a commissioner. They are overseen by a judge, but a judge has more authority
Right. Yeah.
than the commissioner too. So that's kind of that argument of whether whichever one should be by. So that's been really one of those open conversations. That's why I wanted to bring it to this group to see kind of how you guys handle it in the day to day when you're working through these issues. So I love the feedback and the comments and everyone's weigh in on that. So like I said, if you can have that a judge is deferring to the civil and they're comfortable with that, I think that does help provide clarity. But also maybe if the victim's coming to you like, this is like, I'm having issues and I'm trying to get it amended, but haven't, maybe the criminal order can assist in that as well. In that, but that has been a continuous issue with civil versus criminal. So you're not alone in that. Okay, with our sentencing, there are kind of two codes. So we have 78B7 804, and then we have 805. So 804 is 804 is specific to domestic violence cases, and 805 is all of our other qualifying offenses. They're very similar. They just have slightly different language. So you'll see that I've done them slightly different as well. So before the perpetrator who is convicted of domestic violence can be placed on probation, or the court should be considering the safety and protection of the victim and any member of the victim's family or household. The court may condition probation or a plea in abeyance on the perpetrator's compliance with that. So they can make that a condition of their probation and their plea in abeyance, and even to enter into a plea in abeyance that they're going to be compliant with a sentencing protective order. In that sentencing protective orders, the provisions they can include is to not threaten or to commit acts of domestic violence against the victim or family or household members, to not harass, telephone, or communicate with the victim directly or indirectly, to stay away from the victim's home, kind of those same orders we've already been seeing, and other locations, and to prohibit the perpetrator. This is the main one that's kind of different in the sentencing protective order, is they can do a specific order to prohibit the perpetrator from purchasing, using, or possessing a firearm or other specified weapons, and also to order to surrender any weapons the perpetrator owns or possesses. So they can actually write in the order, like, you need to surrender weapons by this date to this law enforcement agency. They can also impose any other conditions necessary to protect the victim and any other designated family or household member, or to rehabilitate the perpetrator. So they can include things that they feel like are going to rehabilitate the perpetrator. For the offenses that aren't domestic violence, it's going to look really similar, right? So, but again, so before a perpetrator is placed on probation for an offense that is not domestic violence, but it's those other qualifying offenses that we listed, the court may consider the safety and protection of the victim and any member of the victim's family or household. The same conditions can be applied to the sentencing or protective orders for non-domestic violence offenses as those for domestic violence sentencing protective orders. Okay, so let's have in our scenario with Rose and Jean. Jean does enter into a plea in abeyance on the domestic violence assault charge, with the other charges being dismissed. So he's ordered to 12 months of court probation. He's to receive an assessment and complete recommended treatment from that assessment, and to pay a $200 fine and abide by the sentencing order conditions. So question is for us is Rose entitled to a certified copy of the sentencing protective order? Ruthie answered yes. I think we're knowing that. That is one of those things too where jail release agreements have such a different language than the rest of ours, because the pretrial protective order, sentencing, and continuous all specify that the victim shall receive a certified copy of the sentencing protective order, where the jail release agreement just has that the victim shall receive written information about the jail release agreement. So that's where I think it's one of those that it's not always caught in statute, right? So that's something that the VSD will be looking at, and hopefully we can clean up that language this next legislative cycle. Okay, so now continuous protective orders. They are in the same statute. They're just the second half of the statute. So we have 804 and 805. So we have the domestic violence and the non-domestic violence, just those differences there. But if the perpetrator is convicted of domestic violence that has an imprisonment sentence, this does include a jail or prison. So it can be that they're sentenced to serve 180 days in jail, or they're sentenced to serve, 5 to life in prison. The court shall, or 15 to life, the court shall issue a continuous protective order at the time of the conviction or sentencing that's limiting contact between the victim and the perpetrator. For other qualifying offenses, the court can issue a continuous protective order if the court determines by clear and convincing evidence that the victim has reasonable fear. So for domestic violence cases, if the person is sentenced to jail or prison time as part of their sentence and their conviction, it is that the court shall enter it. For other offenses, qualifying offenses, the court should determine if there's clear and convincing evidence that the victim has reasonable fear for their future. So it's not an automatic for the other qualifying offenses like it should be for domestic violence, but the courts can issue a continuous protective order for the other qualifying offenses.
Vickie, can I make a comment?
Yeah.
So it's important with that is it's just if they're sentenced to jail time so if they're sentenced to jail time but then given time served, that still counts as being sentenced to jail time. So the continuous protective order should still go in, but it's also important that I find prosecutors and judges forget a lot of times. So it is something that you need to make sure you're advocating for with your clients. That, hey, they absolutely need a continuous protective order. Please make sure you ask for it at sentencing.
Thank you, Lonnie. I really appreciate you saying that, because I think that is so important that maybe if they're not going to get booked and put into jail right away because they already are getting credit for time served, they still were sentenced, right? And they're getting credit. So that's so important. Thank you, Lonnie. And I think that's another way we really can advocate for our advocates or for our victims of crime. Thank you, Lonnie. And please correct me if you have other things or if you have other additionals, because you are in this every day. So I appreciate that. The court can choose not to issue the continuous protective order if on domestic violence cases, if the court determines by clear and convincing evidence that the victim does not have a reasonable fear of future harm or abuse. So in the statute, right, on domestic violence cases, it shall issue one, but they were not going to issue one because the victim has come to us and said they absolutely don't fear them, they don't want it in place, and they have been given clear and convincing evidence that they are not fearful of the victim's safety. The court does need to conduct a hearing in regards to it. The court shall notify the perpetrator of the right to request a hearing if they want to be addressing the continuous protective order. And a victim has a right to also request a hearing, so the perpetrator or the victim can. And then the continuous protective order shall be in effect while the hearing is being scheduled or it's pending. So still those conditions would be in effect until the hearing is held, whether it was requested by the victim or the perpetrator. So let's say that we have that our case was not a Class B misdemeanor and we had an aggravated or an attempted homicide case, right? And it's now that they've been sentenced to a prison sentence. And the victim does not want the continuous protective order in place. They want to maybe be able to send letters or communicate with the person in prison. They can request a hearing, and then they would be giving clear and convincing evidence of why they're not fearful for domestic violence cases. And then the prosecutor should use reasonable efforts to notify the victim of a hearing. So if the perpetrator requests a hearing to review the continuous protective order, they should be the prosecutor is supposed to make reasonable efforts to notify the victim. This is one of those reasons why it's always so helpful to educate and make sure our victims know to keep their information updated with the courts, so that we can give those notifications for them. This one is so kind of just additional information. A continuous protective order is a permanent order, and the things that it can include is to not threaten to commit or commit acts of domestic violence or violence against the household member or family, victim or other family or household member. Sorry, I've been saying those words so many times, it's getting mixed up. They can order them not to harass, telephone, contact, or communicate directly or indirectly with the victim. They can order the perpetrator to pay restitution as part of the continuous protective order and any other order the court considers necessary to protect the victim. Okay, so questions on the continuous protective order? Okay, so criminal protective orders with juveniles. So if we have a juvenile offender, they're kind of a little bit different. So if you have a child listed as a protected party, right, they can have those additional orders as part of that. But if the offender is a minor, this is kind of those differences there. So with jail release agreements, they're not issued against minors. Jail release agreements aren't issued against minors unless the offense is domestic violence. So let's say maybe you have a 16-year-old and another 17-year-old. They are considered in a cohabitant relationship. Let's say the 16-year-old is pregnant with that 17-year-old's child, and there's a domestic violence committed, right? It's not a parent with the child. That's until the child's an adult. That's not domestic violence. So that's the only time where they would be able to issue a jail release agreement is if it is a domestic violence with a minor as the offender. And the jail release expiration is the same as adults, or it can also be the condition where juvenile court terminates their jurisdiction. So the juvenile court is saying, we're not having the jurisdiction anymore. It's now going to district court, or they are terminating the case or things like that. That would be the same for them. For pretrial protective orders with juveniles, they can be issued for qualifying offenses on pretrial protective orders. So those same qualifying offenses. It expires when a sentencing or continuous protective order is issued, right? We know those additional orders as you progress, the new order supersedes the previous, right? Or the court makes a disposition that's under this Title 8, that's in regards to juvenile court, and also for, I had the code up, but let me show you guys that code. It is in regards to adjudication and disposition for juvenile justice. So anything within that kind of code is where that's referencing. And then, or the juvenile court terminates jurisdiction. So you could have, let's say that the case, one of the cases that I had where it was a 16-year-old had sexually assaulted had raped and kidnapped an adult female. They they can no longer do this, but at the time we could. They split the case where part of it was charged in juvenile, part of it was charged in adult court. But as soon as the district court has jurisdiction, they would be the ones issuing those orders. So if juvenile court terminates their jurisdiction, that's also when that would expire. It would have to be then reissued within the district court. For sentencing and continuous protective orders, unless the juvenile court transfers jurisdiction of the offense to district court, a continuous protective order may not be issued against a perpetrator who is a minor. So those continuous protective orders, because they're a permanent order, they're like a lifetime order, unless the court case now is the juvenile is being tried as an adult. And Lonnie, correct me if I'm saying this incorrectly from the statute, that they don't issue continuous protective orders for the minor offender unless it's now being in district court and they're being tried as an adult. So the pretrial protective orders is kind of that area where they can issue them and they can do sentencing, but continuous they cannot for juvenile offenders. Did I answer? I think there was a question on the minors. Did I answer your question, Eva? Is there more questions or more clarification in regards to criminal protective orders when the offender is a minor?
Oh, I appreciate you. Thank you so much.
Yeah, of course. Okay, sorry, I'm just looking. So with all of our penalties for criminal protective orders, it is dependent on what the charges are for the original court order. So for the original criminal protective order, if it is a felony case, so like our scenario was a Class B misdemeanor, it would be a Class A misdemeanor to violate the jail release agreement or the pretrial sentencing or continuous protective order. But if the charge was a felony, then it would be a felony, a third-degree felony to violate. So if we had an aggravated domestic violence assault and they were charged and convicted, or they were charged with charged with that felony level or sentenced to a felony level, violating that would then be a felony charge for that. They do have a specific statute within the criminal protective orders about notice to victims, and I think that's really important. Obviously, that's part of their right, is to be notified of criminal court proceedings and to be informed and given information on the criminal court. But the court shall provide a certified copy of any pretrial protective order that has been issued if the victim can be located with reasonable effort. If the court is unable to locate, the court shall provide the victim's certified copy to the prosecutor. A sentencing or continuous protective order issued shall be in writing, and the prosecutor is the person that is responsible to get the copy to the victim. The victim shall receive notice of the imminent release of the perpetrator that a sentencing or continuous order is against. So if they have been booked they've been booked into jail or prison, they've been, they're serving time there. Once they're being released, that is part of the notification that the victim should be receiving, notification of the release. The perpetrator, if there is an order in place, the perpetrator shall be notified in writing that the continuous protective order issued at the time of conviction or sentencing continues to apply upon their release. So that's one of those things, like maybe they've served 10 years in prison and they're now getting released. They are supposed to be receiving in written form that those conditions of that continuous protective order continue when they're released. And then the court shall enter a dismissal, termination, or expiration of a pretrial protective order, sentencing protective order, or continuous protective order into the statewide domestic violence network. So that's one of those that they do have to go in and enter that the order was dismissed or terminated or has expired in the system. Okay. Criminal stalking injunctions or criminal stalking orders, permanent stalking orders. So the district court shall issue a permanent criminal stalking injunction if the perpetrator is convicted for stalking or attempt to commit stalking, or a plea is accepted by the court of stalking or attempt to stalking. So even if they enter a plea in abeyance and they're essentially admitting guilt of stalking or attempt to stalk, then a permanent criminal stalking order should be issued. It's a shall. The shall issue a permanent one. So that's one of the reasons that a lot of people get confused that a civil stalking injunction is not it's the only civil protective order outside of children ones have very different rules on whether they can be extended. All the other civil protective orders can be extended past the 3 years with a request. The civil stalking injunctions cannot. And that is because if the person is still stalking them, they have violated the stalking injunction, they're going and the encouragement, the idea is that we're encouraging the victim to report those violations of the civil stalking injunction or to report continuous stalking, and that we would go through the criminal court case to then get a permanent criminal stalking order. So that's why civil stalking injunctions off. That's the biggest reason I've heard why a civil stalking injunction is not continued past 3 years. And the defendant shall give the notice of the right to request a hearing in regards to the permanent criminal stalking order. Oh, it's a mouthful. And then this is all found in 78B 7902. So it's a separate from all our other criminal protective orders. The court shall issue a permanent stalking injunction with the order to restrain the perpetrator from entering the residence, property, or place of employment, and require the perpetrator stay away from the victim, stay away from other locations. Question in the chat, sorry, what is the typical process for the court to provide a certified copy to the victims? This is done usually by the court clerk, is often who does that, or the prosecutor if it is a continuous one. And if the victim is attending in person, they will give them a certified copy in person, or they will mail it to them. You can check with your court clerks. I'm not sure if the certified copy can be considered certified over email. I don't know that. I'd have to check with Amy, but usually it is something that the victim advocates can assist in getting that to the victim if maybe they have more identifying information for them, or things like that as well. But it is to, or the victim can go to the courthouse and request it in person. And they can also issue, I just don't know if it's considered, if it's certified. It probably could still have the seal and stamp and things like that over email. They would typically they could give them a copy of it emailed and then still mail them an actual certified one. But I can double check too with Amy on that one. They can also order the restraining the perpetrator from making contact with or regarding the victim. This one I actually want to just kind of pull up the statute so you guys can see. Oh, sorry. I guess I did not get that one hyperlinked. I'll fix that and get that hyperlinked for you guys. Just really quickly, I wanted to just show you kind of, they actually have a lot of language within this. It was just kind of too much to fit all in the slide. And I think I appreciate the detail that they put in here. Oops, sorry, let me get to our right code here. Okay. So I'm just going to bring it over here so you guys can see it. So, sorry, this might be kind of small. Let me see if I can zoom in. It's this over here, right here, this B. So they can also order, they can order an order to restrain the defendant from making contact with or regarding the victim, including an order forbidding the defendant from personally or through an agent initiating any communication except under subsection 3, which is down here, that's about children, likely to cause annoyance or alarm to the victim, including personal, written, or telephone contact with or regarding the victim, with the victim's employers, employees, coworkers, friends, associates, and others with whom communication would be likely to cause annoyance or alarm to the victim. So I think it's so interesting to kind of see how different languages around stalking. We have a little bit of a broader scope, and also like if you're the person is that the orders against is contacting their employers and saying like you should fire them for this, that's also a violation, right? Or they can order that they shouldn't be contacting their employers or their coworkers. And so a lot of times in our other orders, it's just indirectly or directly, right? That's the board verbiage that they have. Where this one, it does really specify the different ways, which I appreciate. So yeah, I love that it's in statute. I'm going to put the link to the statute here since it's not hyperlinked on there, and I'll get that fixed and uploaded again. But if the victim and perpetrator do have minor children together, the court can consider provisions regarding the custody and parent time rights. So it's not necessarily that they're issuing a custody order. It's more about the way that it's written is that, sorry, let me read it strictly from the statute so I'm not misconstruing that. The defendant, if they can consider provisions regarding the defendant's exercise of custody. Sorry, I meant to put exercise of custody, not the actual custody, but the way that they can exercise their custody or parent time. But the court declines to address custody and parent time issues of that would, they should have a divorce or a parent, a paternal action or things like that, a custody order that's handled civilly for the actual custody order, but the permanent criminal stalking injunction order can address the way that they're exercising their rights for their custody, if that makes sense. So the way that they can, drop off or meet up to do parent time, things like that. Sorry, just wanted to provide that. So it's kind of that quick overview of the different protective orders that we just covered today in a little one graph. I did also include in the folder from Timpanogos Legal Center, they have an entire kind of graph or table of all the different protective orders, civil and criminal. In there, including like workplace, I believe is on there now and things like that, which I highly recommend printing off, keeping a copy, having that handy. That's always been really helpful for me to reference. But just kind of that overview, jail release agreements, it's issued by either law enforcement or jail. The victim can waive the 2 conditions, and it is very time limited. A jail release court order is issued by the judge or magistrate. The victim cannot waive it. It is court controlled and it's limited time that it's in place. For our pretrial protective order, sentencing protective order, and continuous, they are all issued by the court. The victim cannot waive those. And the duration of the case for our pretrial is the duration of the prosecution or the court case. The sentencing is the duration of the probation or the conditions of their sentencing. And a continuous one is permanent. It can be in place for life. And then a permanent stalking injunction is court issued, and it is based on the person being convicted of stalking or attempt to stalk. I still don't really know what attempt to stalk actually would be defined as, but in real life, that's beside the point. The victim cannot waive it. It is a permanent order. Okay, so kind of a few just key updates that I wanted to go over that are in code. We had the legislative update that Heidi did, amazing overview. Just a few things that I wanted to highlight here for you guys on that. With House Bill 539, this is a bill that is just chock full of so much information. That's a weird word, but it has a lot of little changes. I have done an overview. This is not to be construed as legal advice. This is a very non-legal overview. Or not, I don't have the legal jargon. Definitely recommend talking with your legal team and things like that on that. But this is hyperlinked in there for you guys. This just goes through each statute. Each statute is hyperlinked that it changed. And Heidi covered a lot of this. I'm not going to go over everything. That it did cover jurisdiction and where a court case shall be investigated and prosecuted. It also talked about whether separating an offense arising out of a single criminal episode. It also had added additional information under a battered person mitigation is when the definition of a cohabitant is expanded to include minors when one parent, including step parents, is the perpetrator of domestic violence. So that battered person mitigation, to have that be part of the criminal defense. Minors it is expanded in the cohabitant. Normally minors are not part of a cohabitant definition, but it is for that. There is also some information, added some considerations when addressing bail. And then the main thing I wanted just to mention on this is the definition of domestic violence and the changes that happened in this statute. Heidi talked a little bit about this. Some of the things that have been added is extortion has been added as an eligible crime that would have that domestic violence tag to it. There was some confusion originally if interruption of communication device and voyeurism were removed, but they actually were not. They are just now incorporated into, they now added, instead of just specifically naming interruption of communication device and I think like criminal mischief, it is now all of Chapter 6, Part 1, property destruction when it's under that cohabitant piece. They also have the whole portion of burglary and criminal trespass, robbery, and then the other voyeurism piece is now added under the privacy. So let me the one other part that changed in that goes into that was removed as part of there was the caveat of domestic violence does not include enticing a minor or lewdness or lewdness involving a child. That used to be that it does not include that. That has actually been removed from House Bill 90. And House Bill 539 kind of made an agreement that they would remove it as part of their bill. So both bills essentially removed it. So if you see when you're looking at statute, it will say that one changes started May 6th, and then the other will supersede January 1st. Essentially, this actually, the January 1st was in regards to House Bill 90, but because House Bill 539 agreed to make those changes as part of their bill as well, the change is actually already in place. So, this one is really weird, very ones. But I just wanted this green part. I know it's really wordy, but I wanted you guys to see, that people can look at and see the entire list of sex offenses, entire list of property destruction, burglary, robbery, and privacy, which does include voyeurism in there. The one thing that was inadvertently removed from the domestic violence code was unlawful detention, which we know is an issue. That is something that will be addressed in this next legislative cycle that was inadvertently removed in all the different bills that changed the statute for domestic violence. So that one will be corrected. So if you guys want to reference this, you can. The other piece that we've talked a lot about is the stalking has been added to a qualifying offense for criminal protective orders. So that's one bill that I just wanted you guys to be aware of. The other is Senate Bill 323. Like Beatrice said, we have a lot of branding changes as well as structure changes. Our office is still the Utah Office for Victims of Crime. In code, you will see our office doesn't say Utah in front of it anymore, but we are still the Utah Office for Victims of Crime. They just clarified that language a little. And we are listed in the statute as Office for Victims of Crime. The other thing that has really changed is now we have been always under the umbrella of the Commission on Criminal, well, for a long time, I don't know if always, but for a long time, we've been under the Commission on Criminal and Juvenile Justice. That commission will still exist, but now we are July 1st going to be our own state agency, not just us personally, but the Commission on Criminal and Juvenile Justice is being restructured to become the Department of Criminal Justice. Tom Ross will now be the commissioner of the Department of Criminal Justice, and then we will have deputy commissioners that are over that. So UOVC is under the Department of Criminal Justice. Obviously all state agencies still answer to the governor, but we're no longer going to be considered directly under the governor's office like we have been. The CCJJ, that commission will still run as a commission. There will be a director of that commission, the Sentencing Commission, the Victim Services Commission are all of the reference points to our office and to CCJJ is now under Title 75E. So there's a whole new statute that basically was recodified. It is now under that. You will also see that we will be going away from using crime victim reparations, and we will be doing crime victim compensation. And our staff is now compensation specialists instead of reparation officers. That is something that is language that has changed to just be in line with other states, as well as to make sure we're ensuring that we're using language that doesn't have negative connotations with it. So compensation doesn't have that negative connotation like reparations does. So there's a lot more to it, but that's kind of the gist essentially with that. Just some little tips. You can add any ideas or tips you guys have in the chat. Like I've mentioned before, you can only have one order in UC just for each criminal case, but the order can list multiple victims. And a lot of times the way the court clerks get around this is that PDF that I kind of showed you guys the picture of, they would attach, if let's say we have 10 adult victims in different households and things like that, they would attach 10 PDFs to the one order and list each victim. The one limitation is that if you have a victim that's like, no, I do still want to have contact because, this victim has a different relationship with the perpetrator than maybe all the other victims, they can't split that essentially. So that's where, talking and having that conversation with the victim that a civil protective order or civil order might be in their best interest, or you have to talk to an attorney and see if that's the better option for them, because they cannot change, the order has to apply to all the victims. The conditions, sorry. So like the stay away, the no contact, things like that. Yes, so we will be having, all of our forms are changing because we do now, as you can see, have the new logo, that we're now the Department of Criminal Justice. You won't see the logo with the little hand and leaves anymore. That's no longer our logo. So all of our applications, all of our forms, all of our brochures, handouts, everything is getting changed. And we also are changing location, like Beatrice said at the beginning. So those will all be changing. So you can use our current application. If you have copies of that, we obviously will still accept that. But we will be updating and issuing a new application that has the change of crime victim compensation, as well as the address change and the logo change. So many changes. It's been super fun for Beatrice and I because we are the two that are changing all branding. So it's been fun. The one thing that you can definitely find all the criminal protective orders on the court's website, like I showed you guys. Definitely, I highly recommend reading through the code. I know code is boring, but even as I reread through a lot of it, some of those things stood out to me this last time. Educating the court or the victim about those conditions, how to report violations, how to document the violations. I think that letting a victim know even with a civil or criminal protective order, if they're not wanting to report and engage with that process, that protective order likely isn't going to protect them as much as it could if they're going to actually report violations, right? Because at the end of the day, it's still a piece of paper. We want to, some of the things you can do that I would recommend is review your agency's process for explaining orders, checking if you guys have it on the website, your jail release agreement process and waiver process on your website. Making sure your coworkers, your staff, law enforcement, prosecutors that you work with understand the differences between those orders. Review how violations are documented or reported or handled by your agency. So maybe asking those clarifying of like, hey, if a victim reports this, what's the process look like in our agency? Identify a training need in your agency and seek assistance. We're happy to come in and provide training. We're happy to collaborate with the Utah Prosecution Council to do that, or with the Victim Services Commission as well. And then if you don't have a coworker that attended, share the material. We'll be sharing the recording, everything like that as well. So my one challenge, and you don't have to put in the chat, you can share if you want, is what is one change or one thing that really you kind of like, oh, this is an aha moment. How can I improve this process or change that you'll do differently from today's training? So take 60 seconds to think about what you would change, whether that's, having a policy, looking at making sure the policy is on your website, or having that you sorry, it's off just my train right there. One process that you'll review, maybe a partner agency that you want to educate or collaborate with to ensure that there's more consistency happening within those agencies. Maybe one practice that you'll improve, or one question that you'll take back to your team to discuss from this presentation. Those are just some ideas that you can utilize. But like I said, if there's questions, please let us know. Definitely, we're happy to help support. That is part of the reason we wanted to do this, so that people know that we're here to provide support. Amy Hernandez with the court. wanted to be here with today, but had some conflicts, but she's always willing to also help support. And is willing to answer questions with that as well. If you have maybe that you haven't been able to, you can definitely do that as well. Yes, let me give you the statute that has, or the code. This is the bill. Sorry, it does have the link to the statute in it as well, but the bill that is requiring law enforcement agencies to create and maintain a policy in regarding to stalking injunctions, jail release agreements, jail release court orders, or protective orders. It's actually not just JRAs. It is all of those. Is Senate Bill. Senate Bill. I was gonna just say bill because it's weird, but it's Senate Bill 83. Sorry, my hyperlink was being weird for a second. That you can reference back to that. And then if you need help with getting that, or if you want to see other people's policies, we're happy to share that as well. But thank you, everyone. Please let me know if you have questions. I will stay on for a few more minutes. And I know it's a ton of information today, but I appreciate everyone's participation and engagement. I know it's going to be, even for me, I still say CVR because it's just really hard to be changing to CVC, but sounds wrong, but yes. I am going to stop sharing. Sorry.
Hey, Vickie. Sorry, I was going to say, after everybody had asked their questions, can you put up that one screen with the juvenile information?
Yeah.
Okay.
Yeah.
Just want to try to take a.
And it's kind of like I tried to take the pieces that were at the end of each statute on juveniles and to put into one slide, but I know that it's not the exact language in there. So let me grab that for you. Let's see. Yeah, there it is.
We've had a few where we've had some juveniles in a DV situation, and then they actually have a child in common.
Okay.
But like he either committed the crime when he was 17, now he's 18, or the perpetrator is an adult now, and the victim is still a juvenile. So I've had some questions about like protective orders and stuff like that because I know here we do like a no contact order, but it has to go in front of a judge in order for it to mean anything so they can make it an order. And so meanwhile, they're like, well, what do we do before it goes to court or anything happens before adjudication? So since we don't really deal with protective orders, I'm like, I don't know.
Yeah,
so
for sure. No, and that's where there is like the different kind of little caveats when the offender is a juvenile. Yes, Mari, the information is on the Google Drive. I will go through and make sure all the hyperlinks are correct. I know that we missed the stalking one. I missed the stalking one, so I'll correct that. But the current presentation as it is uploaded, as well as some handouts on the like full chart I mentioned from Tim and O's Legal Center, as well as Hayley's presentation. So, but that
I
is
appreciate you guys. Thank you so much.
Thank you, Eva. Yeah, let me know if there's other questions that come from it. Like I said, it's kind of at the bottom of each of the statutes where that's where it's at for juvenile offenders. And the language is a little wonky, so like it always is, right?
It's okay. I appreciate you guys so much. Thank you.
Thank you. Thank you for everyone.
Bye-bye.
Thanks, Eva. It's good to see you.
You too. I'm excited for your guys' new building too. So
Thank
I'll have to come by and see it.
Yes, in the fall, we're going to do like an official open house, but right
fun.
now, as you can probably see, my office is like super empty because we are clearing out everything. So I'm like, it looks so boring in here.
You guys definitely needed a new building.
Yeah, our building's sketchy.
All right. See ya. Bye-bye.